And joining us now is former Trump attorney Timothy Parlatore. Evan just reported that Mark Meadows has been asked about both cases, classified documents and January 6. What would he have testified about your former client? I guess my big question is, are you concerned that Mark Meadows testifying to a grand jury, or would his current legal team be concerned, given the scale of his knowledge about the former president and his time?
Well, certainly when I was a member of the team, I wasn't really concerned about any of these witnesses because, while we certainly did fight issues of privilege to make sure that those things are maintained, our position always was that as long as everybody tells the truth, that is the best defense. So, if Mark Meadows went in and he told everything as it actually happened, I think that that's going to be perfectly fine.
Can I just quickly follow up on that? I mean, between text messages that we've all seen because they were revealed by the committee, between staffers that have been around him, I think there were a lot of questions raised about whether or not, on several fronts, Mark Meadows had information or was aware of information or was in rooms tied to information that would present potential legal jeopardy, not just for him, but also potentially for the former president as well. You're saying that explicitly not possible. There's absolutely nothing Mark Meadows could have said or known about that would be problematic.
No, what I'm saying is based on the information that I have, if he goes in and tells the truth, as his lawyer said that he did, then he's going to be able to place all these things in context so that people can understand that there is an explanation for these things that is very different from what the public narrative has been.
How do you explain defying a subpoena and keeping classified documents?
Well, who defied a subpoena? The information related to this case. No, sure. Well, first of all, if we look at the actual evidence in this case, as opposed to some of the leaked public narrative, what happened was a subpoena was issued, a certain period of time was given for compliance, although additional time was requested. The additional time needed was not granted. Evan did the search that he was able to within the period of time that he was given. He gave a certification saying, this is what I found during that diligent search, actually signed by Christina Bobb. And then, whereas normally you would have conversations with DOJ about continuing searches, they would, anytime I talk with the U.S. attorney, they would say, okay, give us what you can within that period of time, but we'd like you to keep searching. That didn't happen here. Jay Brandt kind of cut it off and said, no, do everything by this date. He gave everything that he could by that date. And then there was no continued conversations, as there would normally be with any professional U.S. attorney's office. And so any of the subsequent searches that were after the time period in which Evan had, to search, a lot of that could have been avoided through, normal interactions. This is something that we do all the time. Elie Hoenig and I had a case years ago. We've worked well together on these types of things. That is not how this DOJ case team handled it. And so they do create this situation where you can then say that they ignored a subpoena, but that's not the reality when you get down to the brass tacks of the actual facts here.
I want to play for you, given that point, and I think this has been a consistent point you and I think some in the current legal team have made, some sound from the former Attorney General, Bill Barr, obviously in the Trump administration. Take a listen.
I think over time people will see that this is not a case of the Department of Justice, conducting a witch hunt. In fact, they approached this very delicately and with deference to the president, and this would have gone nowhere had the president just returned the documents. But he jerked them around for a year and a half, and the question is, did he deceive them?
And I think that's the dissonance here between what you're laying out, what the legal team has been laying out. Bill Barr is not a partisan. He is not, in terms of somebody who would want to necessarily take down the former president. What's your response to that?
Sure, and that's a great word to use, dissonance, because there is, with this case and with many cases, a dissonance between what has actually happened, what the full facts are, and what selected portions get put out into the public sphere. And so Bill Barr is making a comment there based on the information that he's been provided, which is definitely not everything. It's certainly not in context, and it's one of the reasons why why I've been willing to come out at this time. Yeah, I'm a former member of the team. I'm not here to defend the president. I am here to answer questions about, what the actual facts are to the extent I can say it legally, and what the actual law is, as opposed to a lot of the spin that's been going on.
We've learned this week that there is a second grand jury in these probes in Florida. There are venue questions, right? This is legally part of a alleged crime has to have happened where a grand jury is convened. What are your thoughts on the fact that, and a key witness we know is going before this grand jury today, I believe. Right. I understand that Florida may be a more desirable jury pool for the president's legal team. Correct me if I'm wrong. But what do you make of the fact that there is now this second grand jury in Florida?
Well, I would actually kind of put it in the inverse that D.C. is a more favorable jury pool for what Jack Smith wants. And, they started that investigation in D.C. They've had all these witnesses before the D.C. grand jury without ever really examining, is there venue in D.C.? And so I interpret this latest action as them getting down to the end, trying to make a decision and saying, uh-oh, we totally forgot one of these threshold issues. And now they have to kind of go back and fix a lot of the mistakes that they made. If this was something where they were going to do a grand jury investigation and ultimately just issue a report as opposed to an indictment, then there's no court in which we would be challenging the sufficiency of any venue or whether a warrant was properly issued or anything like that. And if they are actually considering now to go the indictment route, then they have to go back and fix a lot of the mistakes. And don't forget, this is an investigation that started before Jack Smith got involved. The National Security Division, as opposed to the Criminal Division, started this way back in May of last year. And so now that they have more of the professional, experienced criminal prosecutors on the case, they have to go back and kind of fix these things.
Can I just briefly ask you, we don't have a lot of time left, but did you guys ever raise, while you were there, issues of venue to the special counsel's team, to Jack Smith at any point?
Unfortunately, your question presupposes that we had actual conversations with that team. It was not something that they were, really open to having conversations about anything with us, at least while I was there.
It's a no?
No.
That's fair point.
No, unfortunately. I would have liked to, but.
Yeah. Well, those conversations are happening now, or at least happened once. Timothy Parlatore, thanks so much for your time. We appreciate it.
Great to have you.